beginning, even before the hearing started, that he did not want to sit on that application, and we therefore said that
before the application was called.
before the application was called up, and we said therefore that the court had no power to sit merely as two. We also said that's not a constitutional sitting, and the court took the position, Justice Nik Hashim and Justice Makinuddin, that we were wrong, and they had the power to sit as two. So then they sat as two on the recusal application, where we raised the two grounds, that is, that Justice Paul has an interest because Raja Petra has been critical of him, so it could be seen. No actual bias was alleged. We are saying it's apparent bias. We said that it could be said that ultimately he has an interest because if Raja Petra is not permitted to publish anymore, he cannot criticize Paul. The second thing is, we said, because of the criticism and because that Justice Paul had already sat on Raja Petra's earlier habeas corpus application, which we say had similar grounds for detention, we said the judge had formed the view that it's possible that the judge had formed the view that Raja Petra is a threat to national security. So we argued that extensively, and the court disagreed with us. So because the court disagreed with us, the Justice Paul came back and they sat as three. So then what happened was, Raja Petra applied to the court for an order that the court sit as more than three, but 5 or 7. Because we said that the issues were very complex, involving constitutional law and preventive detention. So we said there's case law to say in this situation, the maybe more judges are needed. Because we will be also looking at past cases where Supreme Court had decided certain things. The court took the view that that was not necessary and dismissed that application. I don't know for the reasons exactly, but my sense is they also suggested that they had no power. Okay. Then we applied for leave to adduce further evidence to show the court that since he was released, Raja Petra, the criminal cases have been proceeding, and secondly, that nothing has happened to in a way that could be said to be a threat to national security. We said it was relevant to understanding whether the minister had the power and also the correctness of the decision. The court said that was not so and dismissed the application. Lastly, we applied to adduce further evidence to show what exactly the investigating officer Gunn said last Thursday when Gobind Singh was cross-examining him, that he did not investigate into the contents of the Let's Send the Altatunia Murderers to Hell article. That article is one of the 3 articles that the minister said was the basis of his detention. The court also dismissed that. So every application we made was dismissed, including the recusal application. And the appeal is now fixed for hearing on Monday, the 23rd. Any questions?
One of the grounds of detention of Raja Petra and the SK, therefore, was that he wrote an article
entitled Let's Send the Altatunia Murderers to Hell.
Okay.
That is the same article which has become the basis of the sedition charge. So when the investigating officer said there was no investigation, we put this application in because it goes to how is it that the minister could have formed the view that this article was false.
The other 2 articles were...
The other articles go towards the insulting Islam. So, but the court took the view that it was not relevant and dismissed it. Any questions?
Now you apply for the 5 justices because due to the
Complexity.
you mentioned to one more. Can you repeat that?
This is an ISA case. It involves the Constitution. So these issues are very important. And because we said the judge in the High Court had approached it in a very different way, a new door had been opened, a new perspective, I said. This raised an issue which was important because it would have to be considered against the other decisions. But the court said no and dismissed it, and the court indicated that it felt that it had no power because the Chief Justice had denied we had requested from the Chief Justice first administratively for a quorum of 5 or 7. The Chief Justice denied that request and left it as an ordinary quorum of 3. We then came here to apply, so they indicated that they didn't think they had the power to do it, but they did not give clear reasons.
Has there been any precedent before this of the federal court ruling in favor of an appeal against
filed by the Home Minister. Yeah. Was there any case before that they overturned
The minister?
by the Supreme Court?
I can't recall.
Not that I know of.
So Chandra can say. I don't think so. So it's
So usually they upheld the High Court decision.
well, the decisions of the court today, including those decisions which the High Court judge looked at, are quite focused on subjective discretion, which is non-reviewable. But what was argued in the High Court by us was new in some ways. And I think it's safe to say that some of the issues we raised in the High Court had not been considered or considered in the same way from the same approach by the previous Supreme Courts. So there's actually new areas of law that we think are possible to explore, which this court, if it's so minded, could take that approach. My personal view is that the judgment of the High Court came the closest to the original intention of the ISA to deal with groups of people who are acting in a way which is threatening and potentially threatening by violence and so on, organized violence against national security. That was the original intention, because in 1960, when they moved the motions in Parliament, and then 72 for the revision, Tun Razak did say that at that time the act was for the communists, because the opposition queried him. They were worried that they were going to be using the act against them. At that stage, the government committed that it was only for the communists. But since then, the courts have taken a view that because the language of the section 8, which allows for detention, does not say substantial body of persons, then they can use it in whatever way they think appropriate according to that section. Whenever we've pointed to the preamble, which talks of substantial body and so on and so forth, the court says we will only look at the preamble if we are uncertain about the meaning of this provision. But in this case, the judge took a different view, because the Interpretation Act says that the preamble, where it specified that substantial body of persons and so on and so forth, must be read as a part of the act, and therefore was binding on him. So that is the issue that will come up here. What we will be faced with is maybe a mindset that has been shaped by very conservative decisions of the Supreme Court, Federal Court to date, and a new approach that was suggested by the High Court judge here. And that is what the issues will be about.
Any reasons why your friend is not there?
I don't know, I can't speak to that. His presence is not required for this kind of hearing. It's not like a criminal sitting where he should be here.
He needed a break because he's been running to the courts practically every day.
But now that they've decided
Resting at
to
home.
let Justice Augustine Paul sit, you mentioned earlier it's unconstitutional and open for review.
Well,
Because-
if I'm instructed to, then, and with no disrespect meant to the court, because they took a view, their view may be wrong. But in one case before, where in the Vincent Tan defamation cases, at the Supreme Court level, one judge had retired by the time they delivered the judgment, and the judgment was set aside because it was unconstitutional for two judges to sit. So this morning's decision to sit as two is questionable. I say that respectfully, because obviously in law there's always two sides, and we will take the necessary steps to advise clients about the possibilities. But we did reserve our right to challenge the constitutionality and also the correctness of that decision. If we do so, if Raja Petra does so, his only option is to apply for a review, right? On the basis that